I'll ask the attorneys to come forward in 124169, Alex Fisher versus Department of Revenue. Ready? You may.
May I please report the question that appellant poses for this court today is whether or not the Court of Appeals erred in finding that there was subject matter jurisdiction in this case where the DC 27, the document that, as the Court of Appeals has stated, gets the ball rolling in a driver's license administrative hearing, whether the errors in that, in fact, failures to comply with statutory requirements in that document divested the administrative agency and therefore every other court thereafter of subject matter jurisdiction to suspend Mr. Fisher's driver's license. The requirements of KSA 8-1002A are certification requirements that have been listed in the statute for a very long time. But in addition to those, there are additional requirements at 8-1002D as in dog that includes that the certifying officer must state the date on which the notice was served to the licensee. And by virtue of that, that also informs the licensee of the date on which his license will be suspended absent a request for an administrative hearing. They don't fill in that date twice on the DC 27 form, which is a form that was created by the department to help their officers to comply with the requirements of 8-1002. But they use that date and then say the effective date of the suspension will be 30 days after the date of service. In this instance, it's undisputed that Mr. Fisher was stopped and had this police encounter in 2019. However, the DC 27 at both places where the officer fills in a date, paragraph 1 and paragraph 8 regarding the date of service, the officer filled in April 25th, 2019. Inexplicably, somehow, by the time that document became a part of the record, which it's volume 2, in the answer and agency record for this court is volume 2, page 5. Someone has corrected both of those dates to say August. It's still unknown who made that correction, whether it was a police officer when he submitted it, whether it was someone at the department who was reviewing it, which they're required to do pursuant to 8-1002F, or some clerical person. We just don't know the answer to that, but it's undisputed that it said April when it was served on Mr. Fisher and that the date in question actually was August. These courts, the appellate courts have decided that the wrong date in item number 1 is not a jurisdictional issue. They decided that in the Schmidt case, they decided that in the Felgate case, but in each of those cases, the court said, well, subsection A doesn't require the date of the incident. And then they went on to say the date is required in subsection D. That was dicta because that was not what they were addressing, but it was sort of like the wrong date in paragraph 1, date of the incident, doesn't matter. And then the court sort of said, it's not like it was the wrong date in D, which is required. So each of those cases, we believe, supports our position that the correct date in paragraph 8, which is what is required by 8-1002D, the date of service and the date on which the suspension would become effective, absent an administrative hearing, that is jurisdictional.
Counsel, do you agree that subject matter jurisdiction, as it applies to an agency like Kansas Department of Revenue, references the authority or power to act of that agency to act?
Yes, Judge and Justice, sorry, we believe that all of the agency in this case's authority act comes from 8-1002, where it says that proper certification of the items listed in the statute, the statutory requirements, is essentially what confers jurisdiction and authority upon the agency to suspend the driver's license, that it's purely statutory, not constitutional.
So so it's important to determine whether or not the legislature has given the Department of Revenue the authority to act in this instance. And in KSA 8-1002F, it states, upon receipt of the law enforcement officer's certification, the division shall review. Doesn't that phrase, the division shall review, presume the legislature has given the Department of Revenue the authority to act?
Well, what it goes on to say is that the division shall review the purported certification for any obvious errors or factual discrepancies. And if they find those, they shall dismiss any suspension.
They shall make a determination that it should either proceed, the proceedings should go on, or the proceedings should be dismissed. Isn't that action a statutory interpretation using their legislative authority to act?
I understand the sort of quandary, Justice Wilson, and that is right to follow their statutory mandate to dismiss a case where the DC 27 or the officer certification doesn't comply with the statute. I guess you're saying, well, in order to be able to dismiss it by their statutory mandate, they have to assume jurisdiction of the case at that point. I guess our position is because B of that same statute, 8-1002B, says the only thing that confers upon them jurisdiction or authority to act is receipt of a proper certification. And so F is where they determine whether or not they have received a proper certification.
And doesn't
if-
F only require compliance with subsection A? Doesn't say anything about subsection D. It just says if it complies with subsection A, the license shall be suspended.
Yeah, our position is that these other cases that have said, and Schmidt's one, Felgate's one, those are the ones really, probably the Stutzman case also deals with compliance with subsection D. You're correct, Justice Siegel, that it says if it fails to comply with A, they shall dismiss it or should dismiss it. But if you look at these other cases, in the case of either a failure or a refusal, those cases say other information that is required on the certification is contained at D, and that's the driver's name. I mean, I guess I would propose to the court, what if they send it in with a driver's license number for one person and a completely different name? How is the clerk or the admin person at the Department of Revenue to determine whether that's factually?
And it could still be,
inaccurate.
the suspension could still be an error without the agency being deprived of, as Justice Wilson said, the power to act.
Right.
Isn't subsection F what grants the agency the power to act?
I believe it's B that grants them the power to act.
Well,
I
that
don't
talks
know.
about the completion of the certification. F is the subsection that talks about what the agency does when they get the certification.
Right. F confers upon them the authority certainly to dismiss a non-compliant certification.
Or to suspend driving privileges. That's what it says. It says shall proceed to suspend driving privileges.
Right.
Once they
Along with the
determine
procedure
that, once
that-
they determine that it complies with subsection A.
Yes, absent the hearing that is obviously
Sure,
a due
sure.
process issue for the driver.
You keep referring to subsection B, and I've got it in front of me, and I don't see the language that confers anything other than it just says certification shall be complete upon signing and no additional acts of oath, affirmation, et cetera. And then the certification shall be admissible. And I don't see anything that directs or permits the agency to act on anything. In B,
The language that I am referring to, it says receipt of any such certification, copy or reproduction shall accord the department authority to proceed as set forth herein. So it's our position that it is subsection B that accords the department the authority to move ahead.
and I just don't see how that, this gets back to the questions you're being asked. I don't see how that hooks subsection D into anything, particularly when F is so plain. F is very plain. It says that, you're authorized to suspend if subsection A is met, and you don't make any complaint about the information required by subsection A.
Do not. And our issue before the court isn't necessarily that someone, whoever it is that reviews this document at the department, messed up by not dismissing it pursuant to F. And that is something that the Court of Appeals, I think, the very last line of their opinion, that's one of the things we would argue that they got wrong. The last sentence, which is also the last full paragraph of the opinion, says, since Fisher only challenges KDOR's authority to suspend his license and not the reasoning of its decision to do so, we need not address whether the KDOR should have dismissed the case because of the mistakes on the DC 27 form. I think they're referring to sort of an argument that they should have dismissed it pursuant to F before we ever got to this place. But the Court of Appeals reasoning that we didn't argue it right at the lower court levels, and this is something that's in my petition, and frankly, a question that drivers across Kansas need an answer to, right or wrong, and that is, if 8-1020H tells the licensee, these are the only things you can raise at an administrative hearing, and wrong date of service is not one of those, and there are many cases that say on judicial review, you can't raise things you didn't raise at the administrative hearing, where then is a driver supposed to raise the issue of a wrong date of service? Failure to comply with 8-1002D is not something that's allowed to be raised in administrative hearing. So we're left with no remedy if they put the wrong name, if they put the wrong driver's license number, if they tell me the wrong date of service, if they leave it blank, if they put words there that aren't even found in the English language, they just fill in a series of numbers and letters for the date of service on number 8, we would have no remedy.
Well, counsel,
Well, let
that's
me-
not exactly right, though, is it? Because KSA 8-1020P states that those things that would apply to constitutional issues, such as due process or any search and seizure or inappropriate manner in which the highway patrolman conducted himself, all of those things can be raised before the district court under P, can't they?
I don't know that countenancing this wrong date as a due process issue is, we saw it better as a jurisdictional issue, that it's not proper certification if you don't comply with the statute. They didn't. And who's to say whether that's just a minor error or the Court of Appeals couched it as a clerical error.
Well, you have to request an administrative proceeding within 14 days, right?
Correct.
So for example, if the service of the certification was inadequate, the name was wrong, or some mistake was made, and he waited more than 14 days to file an appeal, wouldn't those things be considered by the administrative hearing officer to determine whether or not the late appeal should be considered anyway?
I guess that assumes that everybody would look at that document and say, this is clearly wrong. In our case, for example, they received it, it's file stamped, the one that's in the record, on August 30th of 2019. And it said April 25th is when my client was served. So by the date of service, he should have requested a hearing by May May 9th. And if they got his request for hearing on August 31st, his request is not timely. But because they all said, surely the police officer meant August, not April, we've fixed this, then it's timely.
Well,
But-
your client filled out an affidavit that he was actually served on August 25th, and didn't the officer admit that was true?
Yes, but I was trying to sort of get to the court's example. If this had, instead of something so blatant as August versus April, been, let's say he's actually served on August 25th, but the officer wrote August 15th. That would make then his request due on August 29th. But our client knows he got it on August 25th, and he goes and takes him a few days to get counsel, then counsel sends his request for hearing, and it doesn't get filed until August 31st. The department, just looking at that, doesn't know that's a wrong date. So they would believe then that his request was untimely.
And you're
And-
presuming a prejudice that did not occur in the case of your client, correct?
Right, and it's our position that when we're dealing with subject matter jurisdiction, I don't believe that we need to show prejudice. But I would agree, he was not prejudiced by this.
And
error
that's-
date,
Can I
except
ask-
having to be here.
Can I ask you a possible statutory construction that arguably could incorporate the requirements of subsection D into the subsection F analysis by the Department of Revenue? So subsection A2 does say that or requires certification that the officer had presented the person with the oral and written notice required by KSA 8-1001 and amendments thereto. Actually, that's 8001. What are those requirements?
Number one,
Yeah, in
Um,
1001 as opposed to 10002.
Isn't
What-
that the DC 70?
1001 is the notification aspect where the court is divided between certification and notification. So that you don't have a right to refuse testing, all those sorts of notices.
Okay.
And yes, the DC 70, Justice Wilson.
Yeah, I had confused my subsections here, so that answers my question. Thank you. I'm sorry.
There's statutory construction, looking at your, as I understand your argument in B. For your, looking at the language of shall accord the department authority to proceed as set forth herein upon, and so that's upon receipt of such certification. For such certification, do we look back to A? Finds the certification required by this section shall be signed by one or more officers to certify, and then has paragraphs 1, 2, and 3. That the such certification that B is.
I would argue it's the certification that meets the statutory requirements, which includes subsection D.
Where are there other, I'm not finding other places where it refers to certification.
Um,
Am I missing something?
no, he's
It's
required.
all in A or that reference in B.
Required to certify also by signing, and the absent signature with regard to requirements of A and D was something that the court found to be error in the Stutzman case. That was one where the department argued that he just didn't write hard enough on the carbon copy. And so he really did certify these things, but none of them were certified on the copy that was presented to the licensee. And the court found that jurisdiction was lacking because it was not certified as required by A, B, and D. So we argue that certainly judicial interpretation of what's been required includes the requirements of subsection D for it to be a proper certification. You can't certify falsely and say, this is a good DC 27 I'm giving the department. We're not alleging that this officer was intentionally false here, but it wasn't true. So it was false.
Does use the word certification.
I think that's the certification signing. Yes.
Other questions?
Thank you.
May it please the court, New Win on behalf of the appellee, Kansas Department of Revenue. In this case, on the DC 27, we would like to point out that this mistake that was on the DC 27, which was the date that was incorrect, was not an obvious mistake. And in, I believe, Sandate, the court stated that the Department of Revenue reviews the DC 27 form for quote unquote easily discernible errors like missing signatures or check marks or factual discrepancies. When the Kansas Department of Revenue received this DC 27 and then received a request for hearing, we allowed that hearing to be set and heard. And the appellant makes an argument that there is no way that the licensee would be able to argue that there's a they would not be able to have a remedy due to not being able to argue this discrepancy at the administrative hearing. But as Justice Wilson had stated, KSA 8-1020 subsection P gives the allowance of the district court to hear that type of issue if necessary. The appellant also argued using Wall, Stutzman, Felgate, and a couple other cases in regards to DC 27 issues. And we would like to point out that in Felgate, as in this case, there was no prejudice shown. And the court stated in that case that when a law enforcement officer fills out the notice informing a driver he or she failed a breath test, the time or at least the correct date of the incident is not of the essence. And so we would, as the Department of Revenue, say that because the dates were incorrect, justice was still served in this. There was no prejudice to the appellant in this case, in that this mistake on the DC 27 did not deprive us of jurisdiction to make a decision on this issue.
Bill's made a reference to both state and constitutional. There's no constitutional referred to your agency. Your agency has to get jurisdiction to suspend this license only from statute, right?
I believe so. That would be found in KSA 8-1001. And
Right, but there's nothing flowing from the Constitution that gives
No.
the division authority to do anything.
no,
actually.
not in this case.
Yeah, it's just an odd reference that the Court of Appeals used. Something that probably needs to be cleaned up. Statutory, so now the question is whether the statute kicks jurisdiction because the officer made a mistake on this date.
And we would also say that it would not be the legislature's intent if there was a simple mistake, like in this case where a date is incorrect, that we would have to dismiss the case. And it wouldn't be in the best interest of the public safety to have possibly drunk drivers on the roads.
Well,
Just because,
Isn't the question, the fundamental question is, did the agency have the power to suspend this driver's license?
yes, and I believe that this, sorry,
This may be a semantic question, I don't know, but Justice Bowles' question just sort of tees it up for me, so I'll ask. Is jurisdiction even the right conceptual lens to look through which we should look at this? Because that's typically a judicial, it's a concept that we apply to courts. And here we're talking about the executive branch.
yeah, I would say that perhaps the appellant should have argued more of a due process issue.
Well, I'm
Or-
asking kind of a higher level question, because at one level, it may very well be semantic. In other words, we're asking about the power of the agency.
And the power of the agency comes from statutes. So, I guess, having reviewed all my arguments, with my briefs, I've stated, the statutes and the cases that would help our arguments. I would just say that if for some reason that the Kansas Department of Revenue did not have subject matter jurisdiction to make a decision on a DC 27, I just have an issue with how are we supposed to make a decision on a DC 27 if we have no jurisdiction to make that decision itself? If we have subject matter jurisdiction to review the document and then somehow it's taken away from us, even though on the face of the document itself, there's no crucial missing information such as a driver's license number or a name, as suggested in the petition for review from the appellant, that would just be a preposterous case because we wouldn't be able to serve anybody with a suspension at that point. And even if the appellant's argument that the driver's license and the name didn't match, in order for us to even notify somebody, we would have that information in our system and have to check that information. And if it's incorrect, then we wouldn't be able to suspend anybody at that point. But here it's a date on a DC 27 that at the time we did not know was incorrect. We gave the administrative hearing, the driver's license holder came to the administrative hearing, arguments were heard, a decision was made. Then it went to district court and the same argument was made where the district court found that jurisdiction did exist for the Kansas Department of Revenue and therefore the courts to make a decision on this argument.
That where 81002F comes in. Instructs that the department has to review to see if not, it must dismiss, but otherwise it may proceed. Is that your suggestion that being able to proceed shows that there's continued subject matter jurisdiction?
Yes.
Is that what? I understand your argument. Okay. So.
Yes, Justice. And also I would say that the ability for Kansas Department of Revenue to hear these cases with the DC 27 is conferred in section 8-1002, but also 8-1020 speaks about what would happen at the administrative hearing. And so I would say that that also confers the Kansas Department of Revenue some jurisdiction to hear a case derived from a DC 27. I have no further arguments, justices, unless you. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.